part of it that I'm specifically concerned about and want to just say a few words about is this piece here, which is the transaction under which Win transfers intangibles to the Swiss company. Now, you may recall that we said that Win and the Swiss company had entered into an agreement selling those intangibles for $5 billion, $3 billion to be paid up front, and $2 billion to be paid over time. We mentioned that, but we did not mention, okay, what tax issues might come up as a result of this kind of transaction. So, with that in mind, I created a very high-tech slide. Now, the first thing, of course, is that when you have a sale of an intangible, there's obviously got to be a price. And your Section 482 rules, in particular 1.482-4, which covers intangibles, 482 is going to govern that, and an obvious question is $5 billion price tag, is that arm's length? So we've talked certainly a lot previously about the fact that how you value intangibles is miserable, but you've got that question. We've also mentioned before that there's this commensurate with income concept that we find in 482, in the transfer pricing rules. And what that essentially does is saying, well, no matter whether $5 billion is the right price at the date of transfer, if it turns out later that those intangibles were worth a lot more because their use is so valuable, their use creates so much income in the future through the manufacture of the products, then there needs to be adjustments to that $5 billion in future years. So there's really, as I say, two aspects. There's of the 482 question. There's what's the right price? Is that $5 billion correct or not as of the date of transfer? And then secondly, of course, is there a commensurate with income adjustment in future years? Now, here we're talking about the basic transfer of the intangible property that exists on the date of transfer, and that is, all rights to something. Well, what is that something? Well, it's not only the right to manufacture, under certain patents, certain know-how, patterns, schematics, the kinds of things that constitute intellectual property, but it's also the ability to actually own all of that knowledge, so that if the Swiss company wanted to, it could sub-license it to anybody else without the permission of Win, the parent. Now, contractually, we'll have to put that kind of thing in to, in fact, show that it's a real sale, that all substantial rights have been transferred. In this situation where both companies, are 100% locked together, Do you think, in a manner of speaking, anybody cares about those rights that get written down in this this August agreement? I mean, it really doesn't matter what we write internally within the company because, of course, the Swiss company is not going to independently go off and sell its rights. But we write it, we have a contract for it, and tax authorities and courts take that seriously. It's respected. Now, another question about how we write this down. What is it that we're transferring? How is it different from what WIN retains, what the parent company retains? Well, in the example, we've separated out exploitation of these intangible rights within the United States, which WIN retains, and rights to exploit outside the United States, which is what's transferred to the Swiss company. So you've got to divide it up in some sort of manner which allows it to be defined by contract, which allows a valuation to be made. So this, again, becomes something that has to be created in a way a bit out of thin air. But it is possible to do this. I think I sent around to you back toward the start of the course something about Google being in the news regarding how it had done exactly this with certain of its intellectual property. And as I recall, the articles said that Google had spent several years discussing with the Internal Revenue Service about this and ended up having an advanced pricing agreement which covered how much that intangible would be transferred for. So, I mean, that's a pretty solid way to do this. So, again, here, example, IRS taking these things seriously. Now, the media looks at it and says, gee, this is terrible, U.S. company does all this intellectual property development inside the United States and then transfers it outside the United States and pays very low tax. Well, if society thinks it's terrible, Congress may eventually change the rules, but I don't think you need to hold your breath on that because these things have been around a while, and I sort of doubt that they're going to be changed very quickly. Now, we've talked for a moment about the fact that that one aspect, okay, we've talked for a moment that one aspect is the sale of the intellectual property. So now we have that transaction date, this defined non-U.S. exploitation ability or rights, shall we say, rights to exploit outside the United States is now, as of the transfer date, in the Swiss company. Well, we're talking about products in the high-tech sphere, and we know that this is a continuous development process. Technology doesn't stand still. So if we look at WIN's situation that the R&D is primarily done, maybe I think in the example we say only done here in Seattle at the campus of the company, then we have a little bit of a conundrum. We have, gee, the U.S. rights here in Seattle, the foreign rights over here in Switzerland, all the work being done to keep this up to date, to develop new products that are related to what's been transferred. How do we rationalize this thing? And this is where the cost-sharing agreement, lovingly referred to as a CSA, where a cost-sharing agreement comes into play. And what that cost-sharing agreement does is it allows WIN in the U.S. and the Swiss company to combine their resources as far as paying for this continual development of the IP. So in order to have a valid cost-sharing agreement, which is going to be respected by the IRS, then you need to look at the, 50 pages or so, whatever it is, of 1.482-7T, and you can see that what those regulations want to get to is, in a sense, the development of a common asset by participants, each of which will own a piece of whatever is developed. I think I used an example when we talked about this earlier in the course that, if two farmers have a common boundary and they decide to dig a ditch between the two fields, and they combine their efforts and they shovel out the ditch or they pay for somebody else to do it, what have you. It's just the creation of an asset by two parties, each of whom will have some benefit from it. Same thing here. Conceptually, it's exactly the same thing. So the rules allow WIN and the Swiss company to be participants in this agreement, in this shared development of technology. So what are the specific aspects that will have to be dealt with in order to make sure that this works right as WIN and the Swiss subsidiary go forward? Well, number one, the geographical definition that we've mentioned has to be very clear. In other words, there has to be no overlap of ownership. It must be clear what WIN in the U.S. owns. It must be clear what the Swiss company owns. So that means some appropriate drafting of that original, transfer of the technology to make sure that what you're transferring is identifiable and doesn't overlap with what's left behind. Second point there is platform contributions. Okay, what's that mean? There's a recognition that if two parties are participants in a cost-sharing agreement, one party may bring something to the table. It may be people. It may be physical assets, for example, research facilities. Could be anything that contributes to their ability on a combined basis to do this research. Well, we know the Swiss company, being a brand new company, has zilch. WIN, on the other hand, already has research facilities, has in place a group of scientists and other support personnel. Well, there needs to be some sort of valuation, I should say, of what that contribution is, so that both sides, in theory, are are going to be able to contribute equally. So if Win is contributing these, in a sense, assets, these people that are in place, the research facilities that are already there, there needs to be a valuation of that, and there needs to be a buy-in of that by the Swiss company. Now, before we go on to the next point, notice that, of course, on the sale of the intangibles, which is the first bullet point, and on this platform contribution, Win will be recognizing some income. Win will be paying some tax on that income. There's a real taxable transaction here. Now, normally you'd say, well, gee, it doesn't make much sense to accelerate the payment of tax. But with a structure like this where they are looking at the long term and they're saying, gee, assuming that the overseas market does develop like we think it does and this technology is as valuable as we think it is, the tax benefits to be achieved in the future are much greater than the cost of today for the transfer, for the platform contributions. Now, one other aspect, I won't get into any detail, but just to raise it from the standpoint that, gee, this is another thing that you have to think about. Well, on the sale of those intangibles to the Swiss company, is it capital or ordinary? What's the source? I said that $3 billion would be paid right now, today, and $2 billion will be payable in the future. Can the installment sale method be used to defer some of that gain? So there's a number of issues that would come up just in the transfer of the technology, transfer of the IP, in order to actually decide what the consequences are. Another aspect which I would have loved to have gone into more in detail, but again, just to raise it, the $3 billion. I think we said that Win contributed $3.5 billion to the Bermuda company, and the Bermuda company then put $3 billion into the Swiss company. The whole area of how you finance a foreign company. It's fine that we say, well, gee, we're going to set this up and the foreign company is going to buy the technology, but gee, where's the money going to come from? What's the best way to get that money into that entity? We have this brand new Swiss company which has no history. How do we get money into it? Do we use equity? Do we use debt? Do we try to have outside financing, perhaps with a parent guarantee? What are the terms of that outside financing and the parent guarantee have to be? Does there need to be a payment by the subsidiary to the parent for the value of the guarantee that's given? Will, in fact, the debt from that third-party lender be respected as being money lent to the subsidiary, or is there a risk that the whole situation will be recharacterized for U.S. purposes as a loan from third-party lender to the U.S. parent that's giving the guarantee, and then a contribution to capital to the subsidiary? It's another thing that has to be looked at. But this whole area of how do you get the money into the company, major area to think about. Okay, so now at this point, we've gotten the money into the company. We paid $3 billion. There's $2 billion more to pay. We've identified the platform contribution that Win is making. We have an agreement for that, and that's going to be another payment that the subsidiary has to make. So at this point, we say finally, okay, we have our cost-sharing agreement in place. Now let's go forward. Okay, so the couple of issues on the go forward part is, what are the costs that go into this pool that's going to be shared? What are those costs? So identifying what costs, which employees, are they spending their full time, or is it only half time toward this project and they're spending time somewhere else? You know, should the employees be filling out timesheets so that there's a good, accurate measure of how much salary should be put into this pool? What expenses in terms of rental of premises or other things should go in? Is there equity-based compensation that that needs to be part of this? So there's a bunch of rules in the regulations as to what expenses should go into this pool. And then obviously the last point up there is, well, now that we have our pool of expenses that we continually calculate each year, how much should be taken by Win, absorbed by Win? How much should be absorbed by the Swiss company? And what the regulations do is they say you determine the reasonably anticipated benefits that each party has from their ownership of, you know, their piece of this asset. And or I should restate that. Because each one technically owns different property, but they are sharing expenses to enhance the value of what they own. In other words, the U.S. Company Win owning the U.S. rights, Swiss company owning the rest of the world rights. The idea in the regulations is this reasonably anticipated benefit. So you need to come up with projections in a sense of what's the size of the market for each side. What profitability will there be? How much is this really worth looking to the future, and maybe it works out to 30% for one and 70% for the other, or whatever it happens to be. So this, as you might imagine, is again not an easy calculation to make. Now, you are probably not personally going to be making those calculations, but you need to understand the nature of those calculations so that so that you can understand the issues that arise, both legal issues and practical issues, when you're talking to clients about these things. Yes, Peter?
You said the tax benefits in the future are greater than the cost of the contributions. Could you elaborate on that a little bit?
Okay, I think what you're getting at is that I think you're talking about platform contributions, and that platform contributions are separate from this sharing of the pool of expenses. Platform contributions is one transaction where, in a sense, the Swiss company has to make a buy-in payment to Win in this case, not for the basic technology, but rather for the value of those R&D assets, in a sense, that Win is bringing to the table. So that calculation, that transaction, totally separate from coming up with this pool of expenses, which we then have to split between the parties. So once we then have this pool of expenses, using this reasonably anticipated benefit concept, we work out, okay, well, maybe the future market outside the United States is worth $50 billion. Inside the United States, it's only worth $30 billion. So maybe in maybe total future sales is a way to allocate. Or maybe you go through a calculation of what total profit will be in outside versus inside and use that percentage. So it would depend on the industry and so on as to what might be the best basis for allocating the expenses on and coming up with these percentages for reasonably anticipated benefits.